Good afternoon. My name's Ian Smith. I'm the founder of United States Connect, and on behalf of the Export Council of Australia and United States Connect, I'd like to welcome you today to our webinar. It's the second in our series, and it's on US immigration and visas. As I said, it's part of a series on doing business in the US, and what we're trying to do is we actually sent out a survey and asked people what subjects or what topics they'd like covered, and immigration was number 2. So this will be a monthly instalment. So please keep an eye out and let us know if you're interested in attending future ones. We're very lucky today to have with us 2 US immigration specialists, Patrick Fazzone, who's actually calling in from Washington DC, and Melissa Vincenti. And we also have Stacey Mills-Smith from the Export Council, who you'll be hearing from later on as we wrap the session up. Just in terms of how the session will run today, obviously there'll be a slide presentation. If you do have specific questions, there is a facility on the system to type those in. We'll take note of those and get them answered at the end. If there's any questions that we don't have time for or that we need to take offline, we will respond to you directly via email. So without further ado, I'd like to introduce Patrick Fazzone. Patrick is a partner with Montgomery Fazzone and Taylor, and they have offices in Washington DC and Sydney. He serves as legal outside counsel to a large number of Australian companies seeking to establish and grow their business activities in the US. He's also a specialist on immigration matters and has assisted many and varied companies from Australia over the years to set up in the States and also sort their immigration requirements. And I'd like to hand over now to Patrick, and we'll commence the session.
Thanks very much, Ian. And what I wanted to do is to provide an overview of the U.S. immigration laws and the visa system without getting into details. I believe that'll be details for some of these categories will be handled later on. But I also wanted to discuss a little bit about how visa applications generally are processed and why compliance with the immigration laws is very important. I'd like to conclude with just some positive remarks about how U.S. immigration laws really can be a boon to your business as you seek to expand into the U.S. market. A couple of things to bear in mind about the U.S. immigration laws. They apply to all travel by non-U.S. citizens to the United States, whether you're going for business or for pleasure. These laws are extremely complex, and in that respect they resemble the Australian laws on immigration and travel to Australia, but they're different from the Australian laws. Understanding them is critical, and failure to comply with the immigration laws can lead to adverse consequences, including even a permanent ban on travel to the United States. So it's very important, A, to understand the immigration laws, but also to be very careful in complying with the requirements. Even Australian temporary visitors who go in for less than 3 months still are faced with certain compliance steps, including the requirement to register with the ESTA system online. Anyone going for greater than 3 months for business or pleasure can do so if they obtain a B1, B2 visitor visa, but it's also very important to comply with the restrictions on that class, especially when visiting for business. I believe that will be covered in greater detail later on. If you intend to work in the United States, or you're a company and you intend to transfer staff to the United States, there are various employment visas that can apply to your situation. And it's important to obtain guidance on what visa category might actually apply to your situation and the requirements for applying. The main categories that have been used by Australian business persons are the E1, E2, and E3 visas, the L1A and the L1B categories, and those will be covered in greater detail later on. Now, how visa applications are processed, this is an important area to cover. There are actually 2 U.S. government departments that are involved in reviewing and processing visa applications or requests for work authorization, and those are the State Department, which operates in the consulates in Australia and elsewhere, and the U.S. Citizenship and Immigration Services within the Department of Homeland Security. Anybody that wants to come in to the United States, if they require a visa, must apply for that visa at a U.S. consulate. In Australia, there are 3 consulates that process visa applications. Those are in Sydney, Melbourne, and Perth. Some visa applications, particularly the B1 and E visa categories, are only processed at the consulates unless there's a reason for further review by USCIS, Homeland Security Department. But other visa applications, such as the L1 visas, must actually first be reviewed by USCIS. If USCIS issues its approval, then the applicant applies for the actual visa at the U.S. consulate. Now, in two-step process for some visas, one-step process, well, not exactly one-step process, but primarily through the consulate. For other categories, either USCIS or the consulate may deny your request for work authorization or for a U.S. visa. USCIS can deny a petition for approval for work authorization, or they can request further evidence and then delay the process as they review your application more closely. A consulate can deny your visa application, or it can even send the application to something called administrative processing, which can resemble a black hole and to be avoided if at all possible. The final step, of course, is entry into the United States. You might have a work authorization approved by USCIS, say for an L visa. You might also have your visa issued, visa stamp put in your passport by a consulate. But just because you have that visa does not mean that you're automatically entitled to enter the U.S. And customs and immigration officials on entry have broad discretion to request to question your status or your intentions in entering the United States. And this can happen for any number of reasons, including if someone has concerns about whether you actually are intending to enter to do something you're not authorized to do. For example, working if you're only coming in as a business visitor. Failure to comply with the U.S. immigration laws can lead to results that range from unpleasant to disastrous for your business plans. The consular officers at U.S. consulates have broad discretion to deny visas, for example, if they have doubts about your eligibility for the visa you're seeking. We had one client who thought he had an extremely good case to go in as an investor under an E2 category and was denied the visa because they doubted that he'd actually have the funds that he said he had committed, which was a curious result, we thought. USCIS can send you for further questioning on arrival. You can be denied entry after the long flight from Australia, forced to return, or at least required to undergo further interviewing until the officials are satisfied that you are in fact admissible. You can also be found to be inadmissible for certain actions, such as failing to report a prior criminal conviction when asked on an immigration form. And under U.S. law, you can be determined to be inadmissible for a period of time or for an indefinite period. In order to be able to travel through the United States after that kind of determination, you'd have to obtain a waiver of inadmissibility, which are of limited duration. We had one client who sent over an employee to the United States, the head of their U.S. operations, failed to disclose a criminal conviction, and was determined to be inadmissible for life. And that totally changed his business plans. And of course, if you fail to comply while you're in the United States, you are potentially subject to deportation. But of course, the good news is that the immigration laws are also a very positive tool to as a way to grow your U.S. business operations. Both the E visas and the L visas are a great way to help build exports to the United States by allowing companies to station sales, marketing, and other support staff in the U.S., normally through a U.S. entity set up for that purpose. So it can be a branch office as well. The key is to use these visa programs effectively, and the key to that is, of course, advanced planning. Eligibility typically is individual specific. Some people might be qualified for an E3 professional level position. Others might not be an Australian national and might have to go another route or might not have the requisite educational or business background. So you need to take the time to think through what your forward plans are and what steps you'll need to take to implement them. I think if you're sending staff to the United States or you want to set up an operation there, you need to consider whether your plans involve establishing a U.S. presence and bringing on staff into the United States or hiring them in the United States. When you're building your business in the United States, you might have a blend of local hires and personnel sent over from Australia or elsewhere. You need to consider the time frames for bringing those people on and getting the necessary visas. You'll want to leave plenty of time to review and select the appropriate visa categories for staff that you want to transfer to the United States. You want to leave time for the processing of the relevant visa applications. As I mentioned, visa applications like the L1 can take considerably longer because they are initially reviewed by USCIS. As I also mentioned, that Department of Homeland Security can issue a request for further evidence, and that can significantly delay the process. The E-visa categories, particularly the E3, are generally quicker because they're reviewed and processed by the U.S. consulates with only relatively minimal initial steps in the United States. A few concluding remarks in this overview. The U.S. government's objective is not just to screen out and exclude temporary entrants to the United States. U.S. government officials will tell you that we also want to encourage legitimate business and recreational travel to and stays in the United States. If you use the U.S. immigration laws properly, they can provide a tremendous advantage for your business plans. Ian, that concludes my remarks.
Fantastic, Patrick. We're just waiting for the other speaker, and we may need to get them to call in by phone.
I'm here, Patrick.
Oh, fantastic, Melissa. We're just not showing up on the system, but that's fantastic. So, everyone, I'd like to welcome Melissa Vincenti, who's a senior member of the Immigration Law Practice Group and the only immigration lawyer for Nevitt Ford. She provides specialist U.S. immigration advice and visa assistance to corporate clients and individual private clients on all aspects of U.S. immigration law. She's got extensive experience advising entrepreneurs and startup companies with a special focus on the IT, manufacturing, engineering and educational industries. Prior to joining Nevitt Ford, Melissa was a senior associate in a leading global immigration law firm in Sydney, and prior to that was the owner of a private immigration law firm in Honolulu, Hawaii. Melissa, thanks for joining us this morning, and I'm glad we finally got you on the line. We were sweating on it, but I understand you're in Brisbane today, so welcome.
Thank you so much, Ian, and Patrick, welcome as well. Can everybody hear me okay?
Yes, we can hear you. The other participants are on mute, so we can hear you okay.
Fantastic. Okay, and Ian, I cannot switch to the next slide. So as I kind of go through this, if you could just advance the slide.
Absolutely.
Fantastic. Good morning, everybody from Brisbane. It's a beautiful sunny day here in Brisbane. I hope everyone's well this morning. Just following up on Patrick's very informative slide presentation and the remarks that he made earlier, I'm just going to go through a couple of the categories that we most recently usually come across when it comes to Australians looking to do business in the U.S. Now, this isn't a definitive across the board every visa category. What we just wanted to do today is to give introduction to the categories that are used most frequently. And then, of course, if there's questions afterwards, either Patrick or I can answer any of those questions. So the first slide, we just talk about the overview of the categories that were discussed briefly. And Patrick did touch upon the visa waiver program as well as the B1 and the importance of understanding what rules and regulations govern those two areas, traveling either on a visa waiver for up to a 90-day stay for business or on a B1 visa that you have to apply for at a consulate, which allows for a business stay up to 6 months. And again, it's good to have advice, at least initially, as you're going to the U.S. to set up a business, because these categories could be quite narrow in their interpretation of what you can or can't do while doing business in the U.S. And so generally these categories are used for general business operations in the sense that you're going to do an investigation on opening a business, signing contracts, having meetings with clients, just in those general areas. If you actually are going to the U.S. to do productive work, for example, going as an engineer, working on a project, even if it's for a short amount of time, you do require a work visa in those instances. So if we just look at the next slide, thank you, Ian. We can just look at what the differences between the visa waiver program and the B1 categories are. So again, visa waiver program, it is what it sounds like. You don't need a visa, but you do need to register online through the ESTA program to be able to travel to the U.S. On a B1 visa, that is something, a visa application has to be made at a consulate abroad, and you do have to show evidence of your funds going to the U.S., your intention to return to Australia or to your foreign country at the end of your stay, maintaining that residence outside of the U.S. But it does offer a little bit of a longer stay for those who are doing more of an investigatory trip, or if you're going over representing your Australian company in negotiations, for example, in the United States. Let's now look at the next categories, the L and the E1/E2 categories. Now these are a bit broader for the more seasoned companies that do have operations established abroad, for example. That would be probably an L category for executive and managers, or an L1B for specialized knowledge. These are, though, I think we tend to shy away from these a bit because we do have another good option for Australian professionals. So even at a very high level, we often will do an E3, which we'll talk about in a moment, for executives or for those with specialized knowledge. So this is a category that has to be very specific for the situation. Multinational companies or even smaller companies where the person may not necessarily qualify under another visa category, or they're not Australian. So oftentimes we'll see that the person is actually from the UK or for New Zealand, for example. This is quite often used for New Zealanders. But you have to be at a level in the executive capacity or managerial capacity and have already worked abroad for 1 year before applying for these visas. The other category that we have to look at in terms of startups or new companies would be an E1 treaty category or an E2 investor category. It's a treaty trader for an E1, treaty investor for an E2. Now this allows a national of a treaty country, Australia is one of those, New Zealand is not, that allows that person to be admitted to the United States when investing a substantial amount of capital in a U.S. business. Now I often get the question, as you can all imagine, how much money do I need to invest? And oftentimes this category is confused with the EB5 category, green card category, for an investor, where the threshold is either $500,000 or $1 million. That's a very different category from an E2 treaty investor category. And what I always say is it depends on your business. So are you opening a hair salon, or are you investing in an IT company? So what they look at, the consulate, particularly in Australia, look at is what is the business you're starting, or what is the business that you're investing in. If it's a business that doesn't require hundreds of thousands of dollars in capital, they'll take that into consideration in terms of what kind of business, how much capital does it take to start that business, and then we'll determine the visa, whether it's appropriate or not, based on that analysis. So I oftentimes have smaller investors use this category, even under the $75,000 mark. So company that doesn't require much capital up front, maybe it's a media company, possibly it's a small business. But the consulates in Australia are quite open to looking at this category very broadly. So we're very lucky that we have highly trained officers here at the consulate that take into consideration the type of business that is being invested in, and then the qualifications of the applicant. Okay, so if we just look at the next slide, I'm just going to scroll down here. Next category we're going to look at, which is probably the category we talk most about, is the E3 visa category. Now, a lot of people will say that the E3 is just like an H-1B. Well, there's some really significant differences, and I think Patrick touched upon this briefly in his presentation. This particular visa category is used for Australian professionals similar to an H-1B, where a labor condition application needs to be applied for ahead of time. But the main difference of this visa category is that this visa is applied for at the consulate only. We bypass the USCIS requirement of a petition initially, which does save a tremendous amount of time and heartache in many ways. because the consular officer is the one that reviews all of the evidence, including the labor condition application, to make a determination on the visa. It doesn't have to go through a two-step process like an H-1B. Also, the cap on this visa is 10,500 visas per fiscal year. And because Australians have a much smaller population of people who would like to go to the U.S. in this visa category, we do not ever come close to the cap. Last year there were 3,000, I believe, 700 visas issued in this category. So that means the lucky part of this is that you can apply for it year-round. You don't need to go through the season, the H-1B season, where you're applying for the visa in April in the hope to start work in October. So that's a major advantage for Australians in this category. The other huge advantage, I think this matters to a lot of people who are transferring families, is that the spouse gets work authorization under this visa. So that really does help an entrepreneur who wants to move their family to the U.S. then be able to establish their life there a little bit more easily than if you were under an H-1B. And children may also attend school under their visa as well. So we just move on to the key points then. What I'd like you guys to just take away from this brief talk is that you do have several really good visa categories available to you, but it's best to talk this over with someone who can guide you through some of those nuances of each visa category and to get the advice that's suited for you and your situation and your business and your family. Also start early in the visa process. I think Patrick would probably agree with that across the board, is if you can, think about this earlier in the business cycle. So as you're thinking about doing that expansion or starting that business in the U.S., to start early and think about visas ahead of time. It makes our job easier. It also makes the transition to the U.S. easier for you and your family. And the final thing that I'd have to say is don't make any permanent decisions like selling your house. You not believe how many clients I have who put themselves under tremendous pressure in the end waiting for their visas because they've already sold their house, they're living out of their hotel, they've got the kids that they've got to register for school. So the biggest advice, and the consulate will say this as well, is don't make your travel plans or any permanent decisions like selling houses until after you have your visa. Now, I know that's not always practical, but if there's a way that we can start earlier in the process, that helps a lot. So that's what I hope y'all take away from just this really quick overview of those visa categories.
Fantastic, Melissa. Thanks very much for that. We're now going to go to some questions, and I just wanted to kick it off, and I know that Stacey's got a couple here that have come from the audience as well. One of the questions we get asked a lot by companies going to the States is what they can do on the visa waiver in terms of business. So a lot of companies are going to trade shows and they may or may not be writing orders. I know that there's some wording around the visa waiver in that respect. Would you like to comment on that first, Melissa, and then if you could follow up, Patrick?
Sure. I think in general, and I think Patrick again would agree with this, is it's really case specific to exactly the activities of the client. Now, writing orders, that can get a bit tricky because there is some regulations that talk about whether or not, if you're going to the U.S. to write orders, whether or not those products will be sold in the U.S. or not, where that revenue is going to come from. So in that question, I think it's best to talk about the situation directly with the client or with somebody who has those questions, because in one instance it may be appropriate. They can use the visa waiver because of where the goods are going to be sold or what they're doing there. In another case, it may not be appropriate. So I think it's best to talk that through a bit, and also I think be a bit more. Be honest about your situation. If you really need to get to the U.S., and I think the biggest area that people always have questions about, I'm going to be a consultant. So I'm going to the U.S. to consult with my clients. Now, that sounds all good, and that generally can be covered by the visa waiver. The visa waiver and the B-1 visitor visas have the same requirements of how you can do business there. So there's no difference. It just depends on how long you want to stay. And so the consultancy gets very, very tricky. We have to be careful about how, what you're going to be doing there. Are you actually writing reports while you're in the U.S.? Are you going to be giving presentations? Who's paying you? How that payroll, how you're getting paid for those consultant gigs? So that's an area that I think we get a lot of questions about.
Patrick, did you have anything to add to that?
Well, my first point is to concur with all of that. I think Melissa's spot on. And The implicit in all that, it really is the need to sit down and think through what exactly you intend to do over the United States for the person who's going to be traveling, to have a clear understanding of what that's going to be, and to have evidence that that's all they're going to be doing. And sometimes that would take the form of a letter from the employer, from the company, or whatever would be appropriate under the circumstances. But having a clear idea about what you should be doing and can't be doing is critical before you leave. For one reason is because on entry, you may well be asked by the official, what is your intention when you come here? What are you doing, going to be doing here in the United States, and particularly, say, for a B visa? You say you want to stay for 4 or 5 months. What's your itinerary, and what are you going to be doing during that period? You've got to be equipped for those questions. And I don't know about everybody else, but I'm usually pretty groggy after that flight over from Australia. So you want to make sure you know what the answer is to those questions.
All right, thanks for that, Patrick. We've got a question here from Ben Tilley, and it's just regarding the visa waiver program. And he wants to know whether after you've used up the 90 days, whether there is a specific amount of time that you must wait before you can apply for another visa waiver. And also, I suppose, in addition to that, he wants to know, can multiple entries be made under one visa waiver? For instance, can you have several trips for 1 week over each of the course of, say, 2 months? Perhaps Melissa or Patrick, either of you, would you like to respond to that?
Sure, I can chime in. And I'm sure Patrick gets this question all the time, as I do. If I go for 90 days, can I leave for a couple of days and come back? Well, nothing's stopping you from trying it, but the problem is just as Patrick highlighted, is that the officer is going to want to know what the purpose is. Why do you need another 90 days? Did you not accomplish everything you needed in that 90 days? What are you going to be doing here? What's your itinerary? And so, again, it's important to remember that that officer, that CBP officer, has complete control over your entry. You know, whether or not you can convince them or show them the evidence, I think is what is key here. You know, and so I do have clients that have left for a very short amount of time and went back and no issues. But I also had the opposite happen, where gone for 90 days, try to come back, and those questions, you know, in terms of did you not finish everything that you needed to do in that first visit. So I think that's kind of, you know, where we're coming from is, you know, if it's a legitimate visit and you do have the evidence to show it, there shouldn't be major issues. But it is completely up to the officer each time.
Okay.
And yeah, and I just wanted to clarify too, something in the question seemed to suggest that the person who asked it thought there was some sort of, that a visa waiver was like a visa. You know, the visas are typically multiple entry visas. So if you have a work visa, you can go into the United States, exit, come back multiple times within the period of time of the visa. The visa waiver is not a multiple entry phenomenon. It's just every time you enter, you're coming in under the visa waiver program. The only thing that needs to be refreshed from time to time is the ESTA registration. So as Melissa said, once you have gone again, when you want to reappear, you know, that could raise issues if you do it too frequently.
Okay, thank you so much for clarifying that. We have another question here from Jordan Bain. He's mentioned that they're going to be investing in an established business in the USA, and they'll be sending an Australian to work within that office. And he just wants to know whether there's a specific visa category that you might suggest. Patrick, do you want to have a go at this one first?
I'd certainly be delighted to, but of course Melissa will want to talk about this because she was talking about the specific categories. But if the intention is to invest in an established business, there are at least 2 options, and there are probably other ones as well. But one option would be to see whether or not it's possible to qualify that investment, depending on the nature of investment, for an E2 treaty investor visa. And if it's a substantial investment, then perhaps it could even serve as the basis for permanent residence under the EB-5 program, depending on the nature of the investment, the size of the investment, and otherwise. So those are 2 certainly possibilities that are keyed on the investment itself. The other is if an Australian company makes an investment into a U.S. company, there's also quite possible for the U.S. company simply to hire that person under the E3 program if he or she is eligible, and that's not linked to the investment at all, but simply there's an employer situation that would arise that might allow for the use of the E3.
Thanks for that, Patrick. Melissa, is there anything further you'd like to add?
I think that covers it really, really well. I think the only other consideration that oftentimes I speak to clients about is how do you want to pay that person? If you want to keep them on an Australian payroll, for example, then you cannot use the E3 visa. The E3 visa is only good for employees that are on a U.S. payroll. So oftentimes it really does come down to the structure of the investment and then how they want to pay that employee.
We might just touch on one more question we've got here, which is from Kapil, who says, what will be the procedures for an early stage venture capital company with a capital of between 5 to 10 million?
I guess I don't understand. Are they asking them what are visa options for the investor? Is that the question?
I think he's added he's basically saying what visa option. Sorry?
Yeah, go ahead. I guess it depends on who we're talking about for the visa. The actual investor?
Yes.
Okay, I think, as Patrick mentioned earlier, the EB-5 is always an option for certain investments, either at the $500 or $1 million mark or more. But obviously there's a lot that goes along with that in terms of, what the company has to show. The process can be quite complex for that. So if they're just after getting a green card for themselves and the family, then that could be an option. But if we're talking about being able to go work then, in that company that they're investing in, then that's a different situation.
Melissa, there is a little bit more background, and we might take this one offline because Capital actually has a passport from India, and he'd like to open a subsidiary or corporation in venture capital and private equity in the States. So Capital will take that one offline, and we'll get the guys to come back with a response.
So that brings us to the end of this webinar today. Thank you so much for joining us. If you have had a question that we haven't answered, don't stress. We will get back to you and we'll take a note of your question. So please sit tight. I'd like to especially thank our presenters today, Patrick Fazzone and Melissa Vincenti, and of course our partner on this webinar series, Ian Smith from United States Connect. A question was asked initially about the presentation and whether it will be available to people who have participated today, and the answer is yes. We'll be making the presentation available, so that's not a problem. So thank you so much for joining us. Thank you, Ian, for bringing us this very insightful presentation, which is the second in our series of doing business in the US. And we look forward to having you all online for our next presentation, which will be next month, perhaps. Next month.
Thanks, Stacey. And just for those of you that don't know, United States Connect is free to join, so it's a membership-based group. There's about 50,000 words of content on doing business in the States. Every aspect, setting up a bank account, logistics, everything else. Melissa and Patrick are both listed as service providers on the site. And the nice thing about United States Connect is all the service providers listed are actually rated by other exporters. So you can go on there and actually read comments about Melissa and Patrick and the great service they've provided to other clients. Don't hesitate to reach out and ask any questions of myself. And if you've got any specific questions from today that we haven't answered, we will answer. And please feel free to email as well. When Stacey sends around our contact details later today. So thank you very much for joining us, and we look forward to seeing you again next month, and Merry Christmas to everyone.
Thank you.
Thank you.
Thank you.